Attorney Herb Saunders, who has a very important announcement and update for us on where we are with this emergency manager legislation and court ruling. Counsel.
Thank you very much. Reverend Anthony, Coalition of Allies, truly a pleasure to join with you this morning. First, I'd like to clear up what has amounted to some confusion as it relates to where we are concerning our referendum and petition effort and the recent decision of the Court of Appeals issued this past Friday. As most of you are aware, on May 17th, we submitted our petitions to the Michigan Board of Canvassers for certification. The Board of Canvassers, on a party line split, denied certification of the petitions. 2 Republicans voting no, 2 Democrats voting yes. We needed a majority in order to have the petition certified. As a result thereof, we filed what is called a writ of mandamus with the Michigan Court of Appeals. A writ of mandamus says to the court that there is a government official who has an official duty to do something, and they have failed to do it. And we are asking you, court, to make them do what it is they were supposed to do. And in this instance, that was certify the signatures and put the question of the emergency manager on the November 6, 2012 ballot. Now, the court issued an opinion on Friday. The court stated in its opinion that Stand Up for Democracy, the plaintiffs whom we represented, had presented 30 years of precedent. 30 years of precedent that said individuals seeking redress of their government must simply substantially comply with the requirements of the statute. And to the extent that they substantially comply with the requirements of the statute as it relates to drafting a petition, that petition should be certified. And just let me back up for a minute. Of course, all of you know that the main issue before the court was whether or not the font size in the caption was in 14 point. We argued that the font size was indeed in 14 point. We argued that alternatively, to the extent you find that it is not in 14 point, in accordance with Michigan case law, we have substantially complied with the statutes. The court acknowledged that our font was in 14-point Calibri. The court said, however, 14-point Calibri is not 14-point. That's what they said. They said that the statute was written in 1954, and we don't care what Microsoft says when you click on your computer and it says 14-point Arial, 14-point Calibri, or what have you. And we understand that you can have various fonts that will be of different sizes, and they will all particularly be in 14 point, or they'll all be in 12 point, be in various sizes. But we don't recognize the scientific method of measuring point size. We believe that you take a ruler and you measure the capital letter, and all of those capital letters should be of a certain length. And that's how you determine point size, not with your computer. So the court says, yes, you have 14-point Calibri, but that's not 14-point. At least it wasn't in 1954 when the statute was written, and therefore it isn't now. But the court said, but we have to admit that 30 years of precedent that we have established says that all you have to do is substantially comply with the statute. And we have to acknowledge that you have substantially complied with the statute. And we have to acknowledge that, therefore, the petition should be on the ballot. And consequently, we are going to order that this issue go on the ballot. But guess what? Hold on, I'm not finished yet. Hold on, premature. They said now that we've ordered that it goes on the ballot, we're going to stay our own order and not allow it to be enforced, because we feel that the 30 years of precedent is wrong. Even though one of us, Judge Wilder, the controlling case, he was in the majority of opinion that's established the substantial compliance rule. Judge Wilder, who was sitting as a judge in our case, was one of the ones who participated in the opinion that says in Michigan you need only substantially comply with the law. But he says in the new opinion, I made a mistake. We got to follow that rule, but we don't like it. We're going to order that it goes on the ballot, but we don't like it. We're going to issue this order, and we're going to stay it and not let it be enforced. And we're going to ask the Chief Judge of the Court of Appeals to poll the 28 judges of the Court of Appeals and ask them if they will convene what is called an en banc panel. An en banc panel, for purposes of the Michigan Court of Appeals, is a panel of 7 judges who will rehear the case and determine whether or not the 30 years of precedent should be overturned. So that's where we are now. I met with the coalition of attorneys, including the NAACP attorney Butch Hollowell, last night, and we have established a plan of action, some of which I will share with you. Number one, the court has 28 days in which to do the polling of the 28 judges. We will be filing a motion to expedite that polling process. Number two, it is our position that even if the court says we're going to change the rules in the middle of the game, it's our position that the court must abide by the rules that were in place when we played the game and went before the Board of Canvassers. Right. So we are in the process of researching under what circumstances, if any, the court can change the rules of the game and then apply it retroactively. We're researching that for preparation of our brief that we anticipate will file once this polling process takes place. In addition to that, we are researching and preparing to discern under what circumstances can we seek federal intervention. It's our position that potentially in this process, sooner than later, there may come a point where we need to say to the federal courts that the state is not enforcing our civil rights, similarly to the civil rights era, and that we need the federal government to step in and enforce the rights of the people and allow them access to the ballot. So we are undergoing and preparing for that process. We are also seeking amicus briefs as it relates to this issue, basically in 2 categories. Technical briefs from individuals or entities that can substantiate what point size is, and that 14-point Calibri is indeed 14-point, and that the formula that is utilized by us, by the expert for the state of Michigan, whose testimony they would not allow into evidence for calculating 14-point is accurate. So we're seeking amicus briefs in that regard. Anyone have any connections with Microsoft? We'd like a brief from Microsoft, since they called them out and said, your stuff doesn't mean anything. We also are seeking amicus briefs from other entities that will say support us in our civil rights efforts and our right to access to the ballot. So if you are part of an organization that can provide an amicus briefs in either of those categories, we would greatly appreciate it. So I appreciate the opportunity to update you. Thank you very much, Reverend. And one other point, I'm not sure if people are clear on this. I know you know about it, Reverend, but I think I want to mention it. Just to back up, we discerned after we had filed our brief that the state of Michigan had consulted an expert concerning whether or not our font size was appropriate. We were able to get emails between Chris Thomas, the director of elections, and a professor at Michigan State University. And he said to one extent, in a couple of days, I have to argue why 14-point Calibri isn't 14-point. Can you help me? This is an email Chris Thomas sent to this professor at Michigan State University. And he responded confirming that, in fact, the font size was appropriate. But this was evidence that was not made public. It was not presented at the Board of Canvassers. And after 3 motions, the Court of Appeals has not allowed me to present in evidence. So that's something that you, as the public, should be aware of.
We certainly